Hello everybody, and welcome to this next webinar in our series of webinars about cases. And in this series we examine one specific case and talk about it with one of the barristers in the case. And the case this time is about unlicensed HMOs, and the barrister is Dean Underwood, who is a barrister at Cornerstone Barristers and specialises in HMO work. Welcome, Dean.
Thank you very much, Tessa, and allow me to extend the welcome to everyone listening today. Thank you for joining us for this latest in Tessa's series of case-specific webinars. Today, as no doubt you'll be aware, I'm going to talk to you about the very interesting case of Crown on the application of Mohammed and Waltham Forest London Borough Council, as you'll see from the opening slide. If I move the slides on to begin with, you'll see that in fact the case has a much longer title. I'm not going to repeat it, so you'll be able to see it on the slides. It'll take far too long. But importantly, in this case, the Secretary of State thought it fit to intervene because of the significance of the legal issues that were being decided and discussed. Hence my talking about this on Tessa's webinar series. So throughout today's presentation, you will see a series of PowerPoint slides. And for your convenience and for your reference, I've included hyperlinks to various pages on the internet where you can find the materials to which I refer throughout the presentation. All you have to do is simply right-click on the link and you'll be taken to the relevant page. And I've highlighted statutes, decisions, other materials, including cases. Yes, Tessa.
I'm just going to say that we haven't actually put it up
I
as
can
a
still
handout.
hear you, Tessa. If you can hear.
Yeah, we haven't actually put it up as a handout.
Oh, okay, fine.
I will make the slide. We do have a page where we list all of the webinars that we've had in this series, and the PowerPoint will be downloadable from that page. Okay, carry on.
In which case, then take those comments thank you, Tessa, as referable to when you download the presentation and look through it at your leisure. Let me just say a bit more about myself before I proceed. As Tessa rightly said, I'm a barrister and I specialise in landlord and tenant housing, local government and public and admin law. And I had the privilege of being involved in this case right from the outset. And in the divisional court where this case was decided, I was led by a colleague of mine, Ashley Underwood QC, no known relative, although members of Chambers are still trying to get the DNA test done to make sure. We were against the silk on the other side, Imran Khan. Why was this particular decision important? Well, it was important for a number of reasons. So, first of all, it explained the ingredients of the offence of managing or having control of a house in multiple occupation, and the role that a defendant's knowledge, or rather a defendant's ignorance of the facts relevant to that offence might play. Secondly, it considered whether the offence continued so long as the property remained unlicensed, or as Mr. Mohammed argued, as we will see in due course, that it was a once and for all offence, which occurred once and therefore was not continuing thereafter. Thirdly, it clarified the time period within which a local housing authority must bring a prosecution for this particular licensing offence. And then lastly, it clarified exactly what was required of the local housing authority when it started a prosecution. And for your reference throughout, I may refer to this as laying an information, because in legal parlance, that is the way that you start a prosecution in the magistrate's court. So perhaps the best place to start will be with the material facts of the case, so that we have a factual foundation. So what was this case all about? Well, Mr. Mohammed and Miss Lari, husband and wife, are property developers, and they have a large portfolio of properties in Waltham Forest and indeed elsewhere in London. Some of them licensed, some of them not. In 2015-2016, Waltham Forest London Borough Council became aware that various of their properties were actually occupied as houses in multiple occupation, which were not licensed under the Housing Act 2004, as Waltham Forest took the view they should have been. Mr. Mohammed and Miss Lari were notified of this issue, but did not apply to license the properties under Part 2 of the Housing Act 2004, which deals with the licensing of houses in multiple occupation. So the local authority continued to investigate, it gathered evidence, and in 2017, and importantly for this case, more than 6 months after it had first found out about these alleged offences, Waltham Forest began proceedings against Mr. Mohammed and Miss Lari in the Magistrates' Court by laying informations for failing to licence those HMOs. And that was an offence, they said, contrary to Section 72(1) of the Housing Act 2004. Now, I'll come back to that a bit later on so that you understand exactly what the offence is about. So each information or schedule that was placed before the Magistrates' Court was in a standard form used by many local housing authorities nationwide, and it simply alleged an offence committed within 6 months of the date on which it was filed at court. And for example, one of them read like this. On the 7th of July 2016, you did manage or have control of the property at 24 Eastfield Road, London, which was required to be licensed under Part 2 of the Housing Act 2004, but which was not so licensed, contrary to Section 72(1) of the Housing Act 2004. And that's all it said. No further information was provided, and each of the offences was set out in that standard form. And their matters rested for a short while proceedings in the Magistrates' Court ticked over. Well, months later, in the summer of 2017, August, I think to be more precise, Waltham Forest invited Mr. Mohammed to an interview under caution on suspicion that he'd in fact committed a further such offence in respect of one of the same properties. In other words, that it was and remained an HMO which required a licence and didn't have one. Thereafter, in late 2017, Mr. Mohammed and Ms. Lari brought a claim in the High Court for a judicial review. Now pause there for a moment for those of you not familiar with judicial review. Judicial review is a review carried out by the High Court. And when it considers such a claim, it exercises a supervisory jurisdiction. In other words, it oversees the legality and lawfulness of decisions that are made by public bodies, in this case, a local authority. And by bringing that claim, Mr. Mohammed and Ms. Lari were asking the court to consider the lawfulness of the decision that Waltham Forest had made to invite Mr. Mohammed in for an interview. Why did they do that? Well, they alleged that Waltham Forest had been wrong to treat Section 72(1), the offence, as a strict liability offence. In other words, as an offence of which Mr. Mohammed would, subject to any statutory defences, have been guilty, whether he intended it, knew about the facts of the offence or otherwise. To put it another way, an offence which is committed without the necessity of proving any mental elements such as knowledge, dishonesty, intention. So they started that claim. In 2018, separately, they then applied to the Magistrates' Court in the ongoing prosecution, asking the court to treat the prosecutions as a complete nullity. Why did they do that? Well, they advanced two principal arguments. They said that Waltham Forest had not provided the court with, and that the court didn't have, sufficient information about their alleged offences to be able to begin the prosecutions lawfully. And a bit later on, I'll take you through the obligations that a court has when it considers an information laid by a prosecutor and whether it should begin a prosecution as a result of it. And secondly, they argued, because the law obliged Waltham Forest to begin prosecutions for these particular offences within 6 months of them being committed, they said the prosecutions were out of time and that the court therefore had no jurisdiction to try them. And so they said to the court, please essentially strike these out. They are null and void. Well, in 2019, the Magistrates' Court dismissed their application. And as a result of that, in 2019, Mr. Mohammed and Ms. Lari then brought a second claim for a judicial review in the High Court, this time alleging that the Magistrates' Court had been wrong to dismiss their application and asking the High Court to review the district judge's decision. So by this stage, we have two judicial reviews before the High Court, one challenging Waltham Forest's decision to invite Mr. Mohammed in for an interview because they said it was wrong to treat the offence of which he was suspected as a strict liability offence, and the second challenging the magistrate's court decision not to treat the prosecutions as a nullity. Because of their importance and because they involve the same parties, the claims were joined for hearing together by a divisional court, and at that point the Secretary of State intervened in the cases in order to express a view, or rather make submissions, about the legal issues. So, again, moving swiftly on, what were the issues? Well, as you've probably picked up from my summary of the facts, there were three principal issues for the court to determine. Issue number one: did Section 72(1) of the Housing Act 2004 create a strict liability offence? Or was it necessary for Waltham Forest, and indeed any other local housing authority prosecuting such offences, to prove that the defendants knew that they were managing or had control of unlicensed HMOs? Second issue, issue two: did the 6-month time limit for beginning the prosecutions of these offences begin when Waltham Forest first knew the offences had been committed, in this case 2015, 2016, or did it run afresh from each day on which the HMOs remained unlicensed, essentially so that you have a rolling 6-month limitation period? And then issue three: did Waltham Forest provide the court with, and did the court have, enough information to begin the prosecutions lawfully? And would the prosecutions have been a nullity if they had not had enough information? In other words, what would the consequences be of a prosecutor not providing the court with enough information to lawfully begin a prosecution? And so we have three issues, and I'm going to take you through each of those issues, in each case summarising for you the argument put forward by Mr. Mohammed and Ms. Lari and the court's decision. Before I do that, let's again set the foundation, this time not by looking at the facts, but by looking at the statutory offence. I promised to come back to this, and we are dealing here with Section 72 of the Housing Act 2004. Now, that's a long and complicated provision for any layperson to digest, so I'm going to take you through the most relevant parts of it only. So, subsection 1 of Section 72 creates the licensing offence, and it says this: a person commits an offence if he is a person having control of or managing an HMO which is required to be licensed under this part, but is not so licensed. Secondly, under subsection 2, and importantly, as we will see in a moment, there is a further offence, one of three in this section. So a person also commits offence if he is a person having control of or managing an HMO, which is licensed under this part, and then B, he knowingly permits another person to occupy the house. Pause there to note that mental element expressly stated in the offence, and then C, the other person's occupation results in the house being occupied by more households or persons than is authorised by the licence. This is, as you may know, the overcrowding offence. And then under subsection 5, there is a statutory defence. So in proceedings against a person for an offence under subsection 1, or indeed subsection 2 that we've just considered, it is a defence that he had a reasonable excuse for having control of or managing the house in the circumstances mentioned, or indeed for permitting the person to occupy the house, etc., etc. So pause there for a moment. We will come back to this, but note that the first subsection, creating the offence with which we're concerned, doesn't mention any mental element to the offence. The second subsection does explicitly, and that will play an important part in the court's decision in due course. And then note that there is nevertheless a statutory defence. So even if the elements of the offence are established, it is open to a person to say, hang on, I have a reasonable excuse for having, on the face of it, committed this offence. We'll come back to that. One last thing before we move on from the statutory offence. Subsection 1 refers to the person who may be guilty of the offence, and it is the person having control of or the person managing the HMO. Now, there is a long and complex statutory definition of both of those concepts, in other words, having control of or managing an HMO, and it's found in section 263 of the 2004 Act. Again, you'll find a link to this in the PowerPoint presentation that accompanies this webinar. I'm not going to take you through that orally. have a look at it in writing, but pause to note that again, as indeed the court drew reference to later on, there is no reference to a mental element, knowingly or intention, etc., in the definition of a person having control or the person managing. So let me draw a line under the statutory offence there and move on to the issues in particular and consider, first of all, issue 1. If you'll recall, that is the offence in this case, the offence under section 72(1), a strict liability offence? Well, what was Mr. Mohammed's argument? It went along these lines. As a general rule, he said, there is a presumption at law. And that presumption is that a mental element, what we lawyers call mens rea, is required in order for an offence to be committed. In other words, as for example, we see in let's take the offence of theft as an example. In order to commit the offence of theft, a person is guilty if he dishonestly, one mental element, appropriates property belonging to another with the intention, second mental element, of permanently depriving the other of it. So in that particular offence, there is both the physical criminal act, that is appropriating property belonging to another, and there are mental elements, so dishonesty and the intention to permanently deprive. So Mr. Mohammed said, well, actually, there is a presumption at law that all criminal offences contain both the criminal act and the criminal mind elements. And he cited various legal authorities for that proposition. They are well established. There are cases, Sweet and Parsley from 1970, Gammon and Attorney General of Hong Kong, 1985, the Crown on the Application of Mohammed, 2002. Now, as a matter of law, he recognized, and had to because it is well established, that presumption can be displaced. So not all offences will necessarily require both the criminal act and the mental element, the mens rea, or the criminal mind. Those exceptions, circumstances in which the presumption can be displaced, are few and far between, and only in very limited circumstances will the courts recognise or will Parliament have created a truly strict liability offence. So, for example, where the statute addresses issues of social concern, such as health and safety at work, or, for example, is aimed at regulating certain activities for the public good, the licensing of sex shops, for example. And indeed, where strict liability will promote the aims of the statute by encouraging greater vigilance by those who might otherwise commit the offence. So both of those are key elements or key ingredients of the circumstances in which a strict liability might be imposed. So a statute addressing issues of social concern or regulating certain activities for the public good, and where the statute, or strict liability rather, will promote the aims of the statute by encouraging greater vigilance. However, Mr. Mohammed argued this was not such a case. Section 72(1), he said, created a very serious criminal offence for which the penalties and the consequences of those penalties were truly significant. The possibility, for example, of a banning order being put in place, or the possibility of a licence being revoked, indeed the possibility of a very significant fine. And so he said proof of a mental element was essential in order to protect the interests of the defendant. And so ultimately his argument was that to prove this particular offence, Waltham Forest and any other prosecutor had to prove not just that the defendants were persons managing or having control of an HMO, which required a licence and was not so licensed, but also that they knew they were managing or in control of such an HMO. What did the court think of that? Well, the court rejected the arguments. Properly interpreted, the court found section 72(1) created a strict liability offence, which didn't require proof of any mental element, whether that be knowledge or dishonesty or intention, etc. Why was that? What were the reasons it gave? Well, it gave 6 or 7 such reasons. So first of all, it said there was no such mental element stated expressly in either section 72 itself, or indeed in the definition of a person having control of or managing an HMO in section 263. And you'll find that that decision at paragraph 41. Secondly, it said a comparison with the section 72.2 offence, that is the overcrowding offence, in which the prosecutor had to prove that that was done knowingly, was telling. Clearly, the court found, Parliament had addressed its mind in the very same section, section 72, to the elements of the subsection 2 offence of overcrowding, and had chosen to include a mental element. And therefore, the juxtaposition, the fact that it stood right next to subsection 1, which didn't include a mental element, was really instructive. That's at paragraph 42. Third, there was no presumption of a mental element or mens rea when imposing a civil penalty for the same conduct. And so for those of you who don't know, a person whose conduct would amount to that offence under section 72.1 would also, or rather would instead of prosecution, be liable to a civil penalty under section 249A of the Housing Act, Housing and Planning Act, or rather Housing Act 2004, introduced by the Housing and Planning Act 2016. And so the court said it would be inconsistent or incongruous if the criminal offence required proof of it. Fourth, the existence of that statutory defence of reasonable excuse to which we referred a short while ago in section 72 subsection 5 reduced the need for any such mental element. Why? Well, because the court found it would be possible in principle for a person to advance their ignorance of relevant facts in support of a reasonable excuse defence. And so it might be said, for example, by someone who was completely unaware that the property was occupied as an HMO to say, look, I let this to an individual who behind my back went on and sublet it, and I had no knowledge of that. And therefore I have a reasonable excuse for this state of affairs existing. And then fifthly, the offence was typical, the court said, of regulatory offences which imposed strict liability. It was one of those offences which was concerned with regulating a certain activity for the public benefit. And by imposing strict liability, the statute would, or rather this Parliament would promote the aims of the statute by ensuring that those managing or having control of HMOs actually apply proactively for a licence, and thereby indirectly ensure that they would promote the housing standards that Parliament sought to raise by the 2004 Act. And then lastly, the court's conclusion, it found, was consistent with other decisions of the court and indeed the upper tribunal, including the recent case of IR Management Services in Salford City Council. And I've summarised that decision for you on the PowerPoint presentation. I'm not going to take you through it in detail today. Suffice to say, for present purposes, that decision found that the offence under section 234 of the 2004 Act, which concerns a breach of management regulations in respect of HMOs, was also a strict liability offence.
Dean, can I just interrupt very briefly?
Of course.
Firstly, if I could say to people, if you look in the chat, I have now loaded Dean's PowerPoint presentation up to our legal cases webinar page, and you can find links to that and also a direct link to the presentation itself from the chat. We've also had a question which I think perhaps might be relevant at this stage from Patricia, who says, if the landlord raises a reasonable proof defence, what level of proof do they need to satisfy? Is it on the balance of probabilities?
That is an excellent question, and as you rightly say, Tessa, very timely. The answer is, in fact, in the question. It is the balance of probabilities. So while the local authority must prove the elements of the offence to the criminal standard of proof, in other words, so that the court is sure or beyond reasonable doubt, any defence has to be proved only to the civil standard on the balance of probabilities. And so the court would only have to be satisfied, for example, let's take a hypothetical example, going back to the example I gave, that a person really didn't know that the property was occupied as an HMO, and the court accepts that as a fact. It would only have to be satisfied of that on the balance of probabilities. In other words, that there was a 51% chance that that was true. I hope that adequately answers that particular question. Can I answer any others at this stage, Tessa?
No, that's fine. Let's carry on.
Excellent. In which case, that ultimately summarizes the court's decision in respect of the strict liability aspect of section 72. So it created a strict liability offence for which the prosecutor did not have to prove any mental element, but if in fact, on the facts of any particular case, it could be said that the person having control of or managing the property truly didn't know that it was occupied as an HMO, then they might be able to support a reasonable excuse defence. But that would rather depend on the facts and would be an objective question for the court, as we've just said, to be proved to the civil standard of proof. So that's at that point, we can move swiftly on to issue number 2. Did Section 72 create what we call a continuing offence, one for which the limitation period rolls over from day to day, so long as the property remains unlicensed? Or was it a once and for all offence, for which once committed, the time period begins to run immediately and expires 6 months later? So the argument advanced by Mr. Mohammed and Miss Lari before the Divisional Court rested upon Section 127 of the Magistrates Court Act 1980. And that's the section which imposes a limitation period, a time limit, if you like, for prosecutors who bring a prosecution for what's called a summary offence, an offence that is only triable in the Magistrates Court and not in the Crown Court, before the magistrates. And it says this: except as otherwise expressly provided by any enactment and subject to subsection 2 below, with which we needn't concern ourselves, a magistrate's court shall not try an information or hear a complaint unless the information was laid or the complaint made within 6 months from the time when the offence was committed or the matter of complaint arose. Well, Mr. Mohammed and Miss Lari argued, the Section 72(1) offence was committed, they said, either A, as soon as the elements of the offence were all present, or B, at the very latest, when the local authority knew that the offence had been committed, which in this case would have been 2015 in some cases, or early 2016 in others. And in either case, they said, the offence did not continue from day to day thereafter, but was indeed a once and for all offence for which that 6-month limitation period began to run immediately and didn't, if you like, roll over. And so, for the purpose of Section 127, they argued, time had begun to run in this case in 2015 or 2016 at the latest. And so Waltham Forest, they said, had begun its prosecutions too late. What was the consequence of that? Well, they said the prosecutions were time barred under statute, and therefore the court had no jurisdiction to try them. In other words, because it lacked jurisdiction, it was bound to essentially strike them out. What did the court think of that? Well, it was rather short-circuited in the High Court by a concession made by Mr. Mohammed and Miss Lari. So at the hearing, although they'd maintained that position throughout the course of proceedings, they conceded in accordance with a recent decision of the Divisional Court in Luton Borough Council and Luton Althaven Limited, which I've also summarised for you on the PowerPoint presentation. They conceded that Section 72(1) did create a continuing offence for which time ran from each day on which an HMO that required a licence didn't have one, on a essentially rolling basis. And Luton Borough Council and Luton Althaven, I won't take you through it in detail, but was a decision which actually confirmed that very point, that Section 72 did create a continuing offence. So having done so, their alternative argument that time ran from the date on which the local authority first knew the offence had been committed necessarily failed. As the court held, and I quote directly from paragraph 51, if the prosecution prove the commission of an offence within 6 months of the date of the laying of the information, that is the way you start the prosecution, the summons is in time. In our judgment, the judge was right to refuse the application to dismiss the criminal proceedings on the basis that they were out of time. And so in this case, Waltham Forest had begun its prosecutions in time because each of the informations that were filed at court, or laid at court, as we say as lawyers, had alleged an offence that had been committed within 6 months of the date on which it had been laid. And so long as it does that, the court said, then the prosecutions would be in time. Now, it's important to note that the time period for bringing in such a prosecution will eventually expire in certain circumstances. And so once a landlord or a person having control of or managing a property applies for a license, then within the meaning of the Housing Act 2004, it is no longer unlicensed, so long as that application is undetermined and remains effective. And so in that particular case, for example, there would be a long stop on the local authority beginning a prosecution. And that long stop would begin with the date, essentially before the day on which an application was made for a license, and would run for 6 months thereafter. And if the local authority didn't then bring a prosecution within 6 months, well, then the prosecution would be time barred. But so long as a property remains unlicensed, the offence continues day after day, and the 6-month period will continue to run on a rolling basis. And so long as, therefore, the local authority refers to a date that is within that 6-month period, its prosecutions will be legitimate.
Dean, in the situation that you mentioned where the landlord makes an application for a license, what if the application is refused by the local authority? How does that affect it?
Well, once the application is refused, well, then the property becomes unlicensed, again, as a matter of statute, as a matter of law, and letting it out or having it occupied as, for example, in this case, an HMO which did not have a license would again constitute an offence. What's likely to happen in many circumstances is a local authority is likely to say, look, we've refused the license here. Depending on the reasons for that, it may say, well, we don't think you're a fit and proper person to hold a license. We would suggest somebody else and get them to apply. And then it would probably give the person a period of time in which either to make another application from a different person or to ensure that the property was no longer occupied as an HMO that required a license. And if the landlord then failed to take such steps as were necessary to ensure that an offence was no longer being committed, it would start to consider enforcement action, I suspect.
Okay, and presumably, if the number of occupiers were reduced down, that would also let them off the hook as well.
Yes, and it rather depends on the statutory scheme under which an offence is being committed. And so, if it's a mandatory licensing case, then the person managing or having control of the HMO would have to reduce it below the number of persons prescribed by statute. Or if it's an additional licensing case, that is one in which the HMO meets a description of HMOs made by the local authority when it designates its area as subject to additional licensing. If it met that description, as long as it took the property outside of that description by, for example, reducing the number of people occupying the property, well, then it would no longer require a license within that scheme. So yes, reducing the number of persons would be one option.
We've had a question. I don't know whether you want to we want to go here. It's a question about time limits and whether the argument can be advanced for rent repayment order claims.
Oh, that is a very interesting issue, and one which regrettably we don't have time to deal with today. But yes, there is a noticeable distinction between the limitation period under Section 127 in the Magistrates' Court for bringing a prosecution and the time limit for example, I won't mention rent repayment orders, but for example, beginning proceedings for a civil penalty, because the 6-month time limit in which a local authority has to serve a notice of intent to impose a penalty is expressed differently from in Section 127. And so in that case, I don't have the provision in front of me, but I believe from recollection it says the local authority has 6 months from the date on which they first had sufficient information to satisfy themselves that an offence had been committed, and that's a different phraseology from Section 127. And so the argument there would be, well, it would focus on the date on which the local authority first had enough information. It's essentially, Mr. Mohammed could potentially run the argument he ran in this case in the context of civil penalties. Whether he would have any success is another matter.
So there's no case law on that then?
No, that's an issue that I'm itching to take, but before another court. But whether I get there or somebody gets there before me, time will tell.
Okay. Thank you for asking the question, Oliver.
Indeed, another very good question. Thank you very much. So that takes us to the end of issue number 2 and moves us swiftly on to issue number 3. So in this case, was the prosecution a nullity because of the alleged failure of Waltham Forest to provide the court with sufficient information to lawfully issue summonses? Well, what was the argument advanced by Mr. Mohammed and Miss Lari? Well, they said, as we heard at the beginning, Waltham Forest had only provided the court with standard form schedules, very brief schedules of their alleged offences. And they argued that was simply not enough, because in order to issue a summons, according to the case of Crown on the application of West London Metropolitan Stipendiary Magistrate ex parte Clan, another snappily entitled case, in order to issue a summons, the court should at the very least ascertain, 1, whether the allegation is of an offence known to the law, and, note this, whether the essential ingredients of the offence are prima facie present, that is, at first blush present. 2, that the offence alleged is not out of time. 3, that the court has jurisdiction. And 4, whether the informant has the necessary authority to prosecute. Well, Mr. Mohammed and Ms. Lowry said, how could the court possibly have complied with that obligation when, for example, Waltham Forest had not provided any information to the court to explain why they were deemed to be persons managing or having control of the HMOs in question? And therefore the court could not possibly have been satisfied that that essential ingredient of the offence was present. And if it couldn't have been so satisfied, it couldn't possibly have complied with the obligation described in the Clan case. What was the consequence of that, they argued? Well, they said, Waltham Forest's alleged failure to provide the court with sufficient information and the court's alleged failure to meet its obligations at law rendered the prosecutions irregular, and therefore they said a nullity. And the court therefore had been wrong to dismiss their application. Well, what did the court think of that? Unluckily for Mr. Mohammed and Miss Lari, it didn't think much of it. So it said that, in their view, Waltham Forest had provided the court with sufficient information to justify the issue of summonses. So the schedules in this case that I set out earlier described the alleged offences in ordinary language, as was required by the criminal procedure rules and by Rule 100 of the Magistrates Court Rules 1981. And it gave such particulars of the offence as were necessary to give the defendants reasonable information about the nature of those offences. Secondly, it said those schedules included a statement of the offences, again set out in ordinary language, which identified the relevant legislation which created the offences. Again, the court said, complying with the Criminal Procedure Rules 2015, and if you want to take a look at those rules, it's Rules 7.2 and 7.3 in particular. And third, it said the description of the conduct in those schedules made it clear what was alleged. There was no confusion or lack of clarity about it. And from the argument that was advanced before the divisional court, the court concluded Mr. Mohammed's and Miss Lawry's real complaint, the thrust of their argument, was that Waltham Forest had not at a very early stage, at the commencement of proceedings, disclosed to them the evidence, or indeed to the court, the evidence on which the prosecutions were based. But ultimately, the court found Waltham Forest was not required to do that, not to start a prosecution. That obligation would come later on. And then the court considered, well, what would have been the result had the informations laid by Waltham Forest not been adequate to justify the issues of summonses? Or what if the court had not complied with its obligation as described in Clan? Well, it said it would not have quashed the decision to issue the summonses in any event. And that was because of a case called Nash and Birmingham Crown Court, the 2005 case referred to in the PowerPoint presentation. And because further information had been provided to Mr. Mohammed and Miss Lari in the course of the prosecution, at such a time as would enable them to quite fairly meet the case against them in time for trial, they had suffered no prejudice. And so even had the issue of the summonses been irregular, there was no reason to quash the criminal proceedings. They should proceed. And Mr. Mohammed and Miss Lari would be able to defend them in the ordinary course of events during the course of the prosecution. And so that is how the court disposed of the three principal issues that it had to consider. So ultimately, what are the consequences of this decision? Well, we now know that without more, that is, unless there is a statutory defence, a person managing or having control of an unlicensed HMO will be guilty of an offence under section 72(1), even if they didn't intend to commit the offence or didn't know the house was occupied as an HMO. However, a person who was truly unaware that the house was occupied as an HMO, for example, to give an example to which we referred earlier, because they'd let the house to an individual who, unbeknownst to them, had sublet it as an HMO, well, they might rely on their ignorance of those facts to support a defence of reasonable excuse under section 72(5). But whether in any case their ignorance amounts to a reasonable excuse is an objective question for the court or tribunal. And so it would be for the court or tribunal to assess whether it believed the defendant and whether in the circumstances their ignorance, for example, amounts to a reasonable excuse. It might be asked, for example, well, why didn't you, as the person having control of or managing the property, inspect it as you should have done in compliance with various contractual or statutory obligations? And it would then have to assess the reasonableness of that defence. So importantly, however, while ignorance of relevant facts may be relevant and in principle support such a defence, ignorance of the consequences of those facts will not be. So if the person was fully aware of all of the facts that constituted the offence, but wasn't aware that that was an offence at law, well, that won't be a defence, because ignorance of the law is not a defence.
Can I just pick up on that?
Yeah.
Say we have a rent-to-rent situation, which is probably, where this comes in.
Mm.
If someone rents a property to Mr. X,
yeah,
and unbeknown to Mr. X, to the landlord, Mr. X splits it up into lots of different, sub areas and sublets it out,
yeah,
that might be a reasonable excuse. But if the landlord lets the property to Mr. X specifically as a rent-to-rent property, authorising him to sublet it, that might not be the case.
Correct. Yes, I mean it would all depend on the facts of the case, but there would be far less scope for a reasonable excuse defence in the latter case than there would be in the former.
So you need to be really careful if you are knowingly entering into a rent-to-rent arrangement, because you could be liable for your tenant's failure to license. But if it happens without your knowledge, like if the tenant unlawfully in breach of the contract with you sublets, then you will have an excuse, because it was probably against the terms of the tenancy agreement.
In that case, you might have a reasonable excuse, but it would depend on the facts of the case. If the court were hypothetically satisfied that that person genuinely didn't know that the property was occupied as an HMO and had taken steps, for example, to ensure as far as they could that it wasn't so occupied, well, then it might succeed. Going back to what I said earlier, however, if, for example, the court said to that person, well, hang on, as the person having control of or managing this property, you ought to have kept an eye on it, and why didn't you? Why didn't you inspect? Why didn't you double check, for example? Well, depending on the facts, it might not then amount to a reasonable excuse. And for example, there would be even less scope for a reasonable excuse if it were shown on the evidence that that person had in fact gone around to the property during the course of the subtenancy and realized that it was not occupied in the way that they had authorized under their tenancy agreement.
What if the person going round and doing the inspection and not doing anything about it was a letting agent rather than the landlord? Will the landlord be imputed with the knowledge of the letting agent because that person is their agent?
Again, I think that again would be a factual question. I think it wouldn't necessarily, the person wouldn't necessarily be liable as a matter of principle just because the agent knew about it. Is my provisional view. I think it would rather depend on the circumstances. So there would be an inquiry, no doubt, about why it was that the agent didn't pass that information on, or whether it's truly correct that the person didn't know about the occupation of the property, even though their agents were clearly aware of it. So again, I think it would rather depend on the facts of the case.
We've had a question about holiday accommodation. Do you want to make any comments on that?
Not at this stage. I think it's a good question, but I don't think it touches really upon the case with which we're concerned today, and so that's maybe a matter for another occasion. Okay. But I would say that there are, of course, further consequences of this decision, as we know from our discussion of the issues. We know now that local authorities are not bound to begin a prosecution for the Section 72(1) offence within 6 months of first discovering it, and provided the HMO remains unlicensed, they need only begin proceedings within 6 months of the offence alleged in their information. But as I said earlier, that long stop will, however, kick in 6 months from the date on which the HMO ceases to be unlicensed within the meaning of the 2004 Act. And so, for example, if an application is made for a license and remains effective, then the HMO will no longer be unlicensed, and the 6 months finally will roll from that point. Okay. And so that's, ladies and gentlemen, is my, I appreciate, very brief summary of what were complex arguments and submissions in the case of Crown on the application of Mohammed and Waltham Forest London Borough Council. I'm open to any questions that you may have that touch upon this case, or indeed any that you may have, Tessa. Before that,
I think probably we've covered most of the questions. There's a question from Guy. I don't know if you want to have a quick look at that in the chat.
Let me look. So paragraph 44 of the decision, others have argued that this means when a landlord hires a respectable agency, they can rely on the agency informing them of a licensing requirement. When not so informed by the agency, they have a reasonable excuse. Do you agree? When yes, where is respondent superior? We have a case where a landlord who lived abroad hired an agency, asked the agency to license the property, paid the agency to license it, but the agency didn't license it. Where does the liability then lie? A very good question, Guy. And again, in those circumstances, in principle, the person may well have a reasonable excuse defense. Whether or not he or she does so will ultimately depend on the facts. So was it appropriate in all the circumstances of the case for your client, or the person you're assisting, to simply leave it to the agents without any further inquiry? Well, that may depend, for example, on what it will depend on their particular circumstances. The fact that they were abroad and therefore had to rely on an agent rather helps their case. Whether they should, because of the obligations that rest with them, have made checks with the agent to ensure that the property was licensed will no doubt be a question for the court or tribunal. And whether the failure to make those checks deprives that person of a reasonable excuse defense will ultimately be one for the tribunal on the objective facts. But in principle, that is an argument that can be run under the umbrella of reasonable excuse.
I have to say that my feeling is that if you have an agent, the agent is like an extension of you, and you should be bound by everything that the agent does, and it's up to you to choose a decent agent. I know that's rather harsh, but that's always been my view of agency law.
I think as a matter of practice, that's an important point, that you have to be very careful that you are choosing a reliable agent if you're going to rely upon them entirely to fulfill your obligations under the 2004 Act. You are certainly bound by as the principal, you're bound by the acts of your agent. Whether you are taken to have constructive knowledge of the things they know or are aware of is another matter. And again, my provisional view, again, I've not had a chance to look at this in any detail yet. My provisional view is that whether that knowledge would be imputed to you would be a question of fact. So I suspect, I don't think as a matter of principle, you wouldn't necessarily be taken to know exactly what your agent knows, as opposed to being bound by what they do. But again, as I say, a provisional view, I'd be happy to look at that closer.
It's something that well, I mean, I've always been quite interested in agency law, and I don't think it's properly known, or I think people don't seem to take account of it. It is a very powerful thing, an agency relationship.
Well, it certainly is. And as I said a moment ago, as the principal who engages the agent, you are generally speaking bound by acts that they undertake on your part, unless the acts that they undertake are outside of the authority that you've given them. As a general proposition, that stands. As I say, whether that also means that you have imputed or constructive knowledge of the things they know is another matter. And the answer to that, I wouldn't like to commit to at the moment, not having a fully informed view about it.
Okay, we've had a question about Section 247 HMOs, but I think that's probably outside the scope of...
Yes, Section 257 HMOs are probably worthy of a seminar in themselves. But the HMO in this case was not such an HMO, or rather they weren't. So perhaps it's a question for another day.
We've had a question, interesting, another one from Oliver, was saying if a prosecution is to be attempted by a local authority against a managing agent, oftentimes the agency could be dissolved in order to escape financial penalty, which is an interesting...
Yes. Again, I wouldn't wish to express any firm view on that. My provisional view is that then penalizing that agent, or indeed prosecuting them, would become difficult. Quite what the rules are on prosecuting the former directors of dissolved managing agent companies, I don't know. But it would be curious, I think, if a director could simply escape all liability by, certainly criminal law, by simply dissolving the company that had committed the offence.
Hello, you've disappeared, Dean.
But certain questions. Can you hear me now?
Yes. Your connection broke briefly, I think. Yeah. I think perhaps we better leave the questions. I think possibly we better leave the questions on agency just now, because it's not really the issue that's being covered by the webinar. But I have to say, I think it's an interesting one, and maybe it's one we could look at next time.
Yes, indeed, I agree.
Okay, you've got several more slides. Do you want to show those slides, and then perhaps might be time for
yes. In fact,
okay, right.
The only slides left are the closing slides, so I'm happy to show those, but they won't give you any further information. I truly hope that this summary of what has been a very interesting case to be involved in has been informative, and I hope that it's added well to Tessa's recent series on significant case law.
Okay, well, thank you very much, Dean, for explaining it to us very, very clearly and carefully. I thought it was fascinating.
Thank you very much.
As I said before, if anybody wants the presentation, you will find it, but you will be redirected at the end of this webinar to a page where you will find a link to our general pages for the for this series of webinars, and you will be able to download the PowerPoint from that page. So Thank you very much, Dean, and hopefully we will be speaking to you again on another time.
I very much look forward to it, and thank you for inviting me.
Okay, thank you, everybody. I'm going to close down now. Goodbye.